Hello friends, in this video I am going to discuss protection in respect of conviction for offences, Article 20. Article 20 is an exclusive provision that safeguards the rights of a person who is accused of a crime. So in this video I will discuss the provision of protection in respect of conviction for offences. Let's start with the introduction. Protection in respect of conviction for offences. The provision is enshrined in Part 3rd of the Indian Constitution, Chapter Fundamental Rights, Subchapter Right to Freedom, Article 20. Now the question is, what is meaning of protection in respect of conviction for offences? The provision enshrined in Part 3rd, Article 20 of the Indian Constitution preserves the rights of a person who is accused of a crime. Likewise, it is protection in reference to conviction for offences. Now the question is, what are the clauses of Article 20? Following are the three clauses of Article 20. That is, Clause 1, ex post facto law. Clause 2, double jeopardy. Clause 3, prohibition against self-incrimination. Let's discuss each of them in brief. Clause 1 of Article 20, ex post facto law. It states that no person shall be convicted of any offense except for violation of a law in force at the time of the commission of the act charged as an offense, nor be subjected to a penalty greater than that which might have been inflicted under the law in force at the time of the commission of the offense. It means the legislature is restrained to make criminal laws having retrospective effect. Secondly, the provision is applicable only in case of conviction for criminal offences. Next, Clause 2 of Article 20, that is double jeopardy. It states that no person shall be prosecuted and punished for the same offense more than once. It means for the same crime cannot be punished twice. However, this provision is limited to the punishment inflicted by a court of law or judicial tribunal. Therefore, note, this provision doesn't include the person employed in government service. Hence, if a government employee is prosecuted by the court, then Article 20 would not be applicable in reference to his departmental inquiry and subsequent punishment. Similarly, if government employee is punished by his department, it doesn't mean that he would not be prosecuted in the court of law for the same crime. He will be prosecuted in the court of law and cannot claim protection under Article 20 of the Indian Constitution. Next, Clause 3 of Article 20, that is prohibition against self-incrimination. This provision states that no person accused of any offense shall be compelled to be a witness against himself. It means an accused cannot be compelled to be a witness against himself. The basic concept behind this provision is, according to criminal jurisprudence, a person is presumed to be innocent until the crime against him proved in the court of law, and it is prosecution's duty to establish and prove his guilt in the court of law. However, willingly or voluntarily, he can confess and give evidence against himself that is not restricted. Now, the question is, what is a special of Article 20? As I have discussed in my previous video, that is Article 32 of Indian Constitution, that during the emergency period under Article 359, all provisions of fundamental rights will remain suspended except Article 20 and Article 21. Likewise, even during the emergency period, Article 20 remains active and functional. So, this is all about the Article 20, that is protection in respect of conviction for offences.